Number one. Yes.
Item number 1.
Yes. Yes, please.
May it please your lordships.
Yes.
My lord, I'm appearing on behalf of the notices on whom the notice has been issued of the contempt. We have also filed affidavits, my lord. Every one of them have filed, my lord. And we have tendered our unqualified apologies, my lord, and sought for forgiveness. And we have also explained the circumstances under which the whole event occurred, my lord. And it was not intentional. The situation was such, my lord, that the building collapsed. And it was beyond our control, my lord.
Are they present in court?
Yes, my lord. They are all.
Where is the affidavit? Affidavit?
Affidavit we have submitted.
the government report says it on combined evaluation of the square and the location of the building. They want to declare it. We will give them leave to reconstruct, but on that same architectural pattern, and keep the contempt pending. Contempt will be pending. Otherwise, all the fear will go.
Lordship,
Yes.
No, on this.
You have anything to say?
No, my lord. On the contempt, I have nothing to say.
Yes.
On the contempt, my lord, I have nothing to say.
Contempt is between the court and the contempt.
Yes, yes.
What do you have to say regarding the merits?
Merits, my lord, because what we have sought by this PIL is for the school building, my lord. Now that has been demolished, my lord. So, my lord.
All right, please take notes. The alleged contemners are all present in court. Full stop. Their presence be recorded. Stop. Their further presence is dispensed with for the time being. We have heard Mr. Chakraborty, learned senior advocate, appearing for the alleged contemners and perused the affidavit filed by each of them. Full stop. In short, what is stated in the affidavits is as follows. Stop. Next. St. Anthony's Lower Primary School is a premier institution of Shillong. Stop. It educates students between nursery and grade 5 classes. Full stop. The student strength is 650. From 13 January 1922, the school is run by the missionaries of the Salesians of Don Bosco. Belonging to the Catholic Church. Next, the school building was built between 1949 Mr. Chakraborty, it should not be between, in 1949. Page 14, last sentence.
Well, the construction was completed in 1952.
But where is that? In page 15?
Madam, para 3, page 4.
Running page 14. Yes, para 3. Your last slide is between 1949.
Between 1949 to 1950.
That is there.
My lord. At the running page 4 of the affidavit.
So in our brief, it is not there. Anyway, between 1949 and 1952. Full stop. It is 72 years old.
Which initial?
See, oh, paragraph, the building was found to be structurally in or about 2024, the building was found to be structurally very weak and needed large scale restructuring, rebuilding, and renovation. The management of the school engaged Reliant Foundations Private Limited of Guwahati who carried out various tests and advised the above structural changes. Next, matters came to a head at the close of 2024 when the building was found to be tilting and urgent within quotation, urgent and immediate action is called for to prevent any serious damages or accidents. Unquote. As recorded in the recommendation of the management dated 4th January 2025. It has also been stated by that time the Meghalaya Urban Development Authority had approved the plan for restructuring, rebuilding, and so on without raising any question with regard to heritage. Paragraph. Paragraph. Now the question which seeks an answer is that when the order passed by us was made on 9 December 2024, and the school management had full knowledge of it, comma, the court, despite being closed for the Christmas vacation, had vacation benches sitting, comma, why this imminent danger to the building and the need to demolish it was not brought to the notice of the court, was not brought to the notice of the vacation bench, and appropriate leave obtained to demolish the building. Full stop. Full stop. Why, during the vacation of the court, comma, when the matter was made returnable on the very next day of reopening of the court on 28 January 2025, the building had to be demolished, comma, when it was allowed to stand for all this while. Paragraph. The alleged contemners are directed to file an affidavit explaining this by 17th March. Paragraph. Considering the fact that the building has already been demolished, comma, the students have been relocated to another place, comma, it is a premier school in Shillong, comma, the building restructuring plan has been approved by the Meghalaya, that authority, and the view of the state that on a combination of the on a combined view of the square, the statue of Don Bosco, and the facade of the school facing it. The building should be declared as heritage, comma. We permit the school management to rebuild but the architecture of the building should be more or similar to the demolished one. Full stop. In this respect, if the plan has to be revised, it may be so done and duly approved by the Meghalaya so and so authority. The management may proceed with the reconstruction work. Paragraph. We make this application returnable on 19th March.
Highly obliged, Your Lordship. Very good.
Item number 2.
Actually, in this matter, the amicus was supposed to submit the report on the last occasion. We have served the copy to the NHI. Lordship.
I have received, my lord.
If a copy is given to the state as well. Lord.
What is this Dowki Highway?
No, my lord.
National Highway 6.
NS6, my lord. Sonapur Road, my lord. Ratachara.
Joy Ratachara.
Joy Ratachara, my lord.
What have you found?
My lord, I have found, my lord, the patches which I have mentioned in my report, my lord. And I have pointed out those patches to the officials of the NHI. And my lord, page 2 onwards, I have annexed the photographs. If I may come to page 2. There are patches which are in very bad shape, my lord. And this has been pointed out to the officials present.
You have not said nothing about the 5 kilometers and 45 kilometers.
5 kilometers, madam, more or less, they have done it, my lord.
You have not said so.
I have not said so, my lord. I have not pointed out that because those are okay, my lord, in running condition, my lord. Of course, there are bad patches, but I have highlighted only the portions, my lord, which are very much in bad conditions, my lord.
So what I submit.
Verbally, I point out, my lord, to
My
the.
lord, I'm praying that work is going on, my lord. We may be granted some more time to show that this portion of the road also is repaired, my lord. We undertake to repair it.
45 kilometers, how much time you will take?
My lord, one obstacle in this regard is the traffic. We have to manage the traffic besides the work which is being carried out, my lord. Because we cannot completely stop the traffic which is proceeding towards Silchar and Mizoram, my lord. So it has, in that regard, it's creating a bit of a problem, my lord. And we are trying to manage that one, and it will take some time, my lord, but we undertake to complete it, my lord. My lord, I am praying if the matter can come up after 4 weeks, my lord, we will show a progress report in this regard, my lord.
The other aspect, my lord, on the ground reality, my lord, what I have found is the number of persons, my lord, laborers engaged seems to be very low, my lord. The number of laborers engaged in the site, my lord.
What will the court do? The court will be a head mason.
That cannot be done, my lord.
Supervising work.
That cannot be done. I have
And
highlighted.
see.
That cannot be done, my lord.
Then,
Just to expedite the work, my lord.
if there is any gross administrative failure, the court will interfere.
Absolutely.
The court will monitor building of the highway. They are doing proper
I
work.
completely agree, my lord. I completely agree. Just to expedite the work, my lord. I'm just making a small prayer, my lord. Of course, this court
The
cannot
court
do.
cannot become administration.
Absolutely, my lord.
Please take down. We have perused the report of the amicus jury, which was required to be furnished before us by our order dated 5th February 2025, with regard to the progress of the repair work in National Highway bracket NH6 between Joai and Rathachera. Paragraph. We have also heard learned counsel. We have also heard learned additional Advocate General for the state and Mr. Sengupta for the
National Highway Authorities.
NHAI. Paragraph. We have every reason to believe that the work of repair is progressing satisfactorily. Of course, full stop. there are some subsisting problems like large potholes, exposed rods from small bridges, as pointed out by the amicus curiae in his report. Full stop. But these issues are not very major, and we direct the respondent NHEI to resolve them as soon as possible. Paragraph. Considering the submissions made by Mr. Sengupta, we expect that the entire highway of 102.225 kilometers would become safely pliable, without any obstruction within reasonable time. Full stop. We make this application returnable on 16th April 2025. Full stop. The state has got nothing to do with it.
Nothing, Your Lordship, except we need local assistance, Your Lordship, in terms of regulating the traffic or traffic police. Your Lordship, we are always there to assist the NI.
The state and NHAI will file a short affidavit containing a status report.
Or status.
Item number 3.
We earnestly hope that the status report would indicate completion of the project by that time.
Item number 3.
May it please your lordships.
Yes.
Your lordship, as per the order dated 6 February 2025, my lord, I have placed on record the address of the respondent number 2, my lord, as well as I have taken steps, but the steps has not been effected till date, my lord, on the respondent number 2, my lord. She has not acknowledged the steps, my lord. Respondent number 2.
You have corrected the cost title
Yes, my lord, I have corrected the cost title as well.
and sent it at the corrected cost title.
Yes, my lord.
You are appearing for the other respondents.
I'm appealing for the state matter, respondent number 1.
How much more time you require?
My lord, maybe 2 weeks' time, my lord.
The returnable date of this appeal is further extended till 12th March. By which time service should, to effect service on the respondent number 2 and file an affidavit of service to service report in this court.
Highly obliged, my lord.
Item number 4.
Obliged.
Please, Lordship. As per the order dated 17 Feb 2024, Your Lordship, I have made an effort to dusty service. However, that not been affected to the preparation number 3 and 4. So I may be allowed to take a fresh step through postal service, Your Lordship. The preparation.
You have not served anybody.
We have taken a step. I have sent it to the petitioner also, but it seems that the respondent have refused to acknowledge the same. That's why maybe.
Where is the affidavit of service?
Affidavit of service, because then since that person have refused to accept, that's why I could not find it.
You have to mention that in the affidavit of service.
Okay, then the Lordship, that I may be allowed to just file it, or Lordship may be given a liberty to take a step to send it again to register post. At the meantime, I'll file the affidavit of service of trustee, mentioning that they have refused to accept, acknowledge the same.
Advocate on record for the applicant has been unable to effect service. Next, by our order dated 17th of December 2024, we had directed service as well as filing of affidavits by the respondents. Paragraph. Since the respondents would not be served, we recall those directions regarding filing of affidavits. Next, we direct fresh service to be effected. According to our order dated 17 December 2024, we make the application returnable on 12th March 2025. The point of maintainability is kept open.
Lordship. Yes. Highly obliged. First, Lordship.
Item number 5.
This was final hearing, my lord. There's an appeal from the order of the learned single judge under the. Here, what happened, my lord? Some smuggled betel nuts were seized from the possession of the respondent, my lord. Now, the betel nut, after seizure, as per the.
You are ready?
Yes, my lord.
Huh?
My lord. So, my lord, after seizure of the betel nut, as per the procedure followed in the customs department, the samples were sent to food analyst, my lord, whether it is fit for human consumption or not. The report came that the betel nut was of very inferior quality, unfit for human consumption. So, following the customs manual, my lord, we carried out destruction. We destroyed all the betel nut, my lord, because since it was unfit for human consumption. Now, in the departmental adjudication, my lord, initially the first order in original confirmed the demand, ordered for confiscation of the betel nut, my lord. They went to Sestat overturned the decision of the commissioner, my lord.
Yes.
Now, my lord, we came to before this honorable court in appeal, my lord, under the Customs Act. Our appeal was dismissed. We even went to Supreme Court. Even SLP was dismissed, my lord.
SLP was dismissed.
SLP was also dismissed. Thereafter, what they did, my lord, instead of filing an execution petition before the appropriate authority, they filed a writ petition before the learned single judge, my lord, for refund of the seizure value of the goods. Our case before the learned single judge was, my lord, that we did not derive any revenue from because we carried out destruction. Because the betel nut was unfit for human consumption. And we have done so in terms of the customs manual, but the learned single judge directed us to pay him an amount of rupees 60 lakh rupees. My lord. So that is how we are before Lordship, my lord, in appeal.
The last order, my lord, there was a direction that appeal is barred by threshold limit. So this will be taken up first. It's for last order. Threshold limit notification. Appeal is barred by monetary limit of 1 crore. It is at page, my lord, 290 of the paper book.
You see, this point, Mr. Deputy Solicitor General, you argue, this threshold limit is a departmental administrative order. It is an order by the department on its officers that below so much, don't file appeal.
Don't file it. Well,
Above so much, you file an appeal.
yes, yes.
Now, this cannot confer any right on a third party, on a private party. Suppose if the department officer acts contrary to the circular, he will face departmental action.
My lord.
But how can it confer right on the on an SSC?
Supreme Court judgment at 292 page
What judgment?
on the threshold limit.
My lord, our short response will be, my lord, these circulars, even if these are applicable, these are for customs appeals, statutory appeals under the Customs Act, my lord. Here they themselves invoke writ jurisdiction of this honorable court, my lord. And this will not come in the way of our filing an appeal under the writ jurisdiction, my lord.
The Supreme Court order is there, nothing we can do. But the
Taking on
question
the-
is, it is a reign, control on the department and departmental officers.
Yes, they should not file appeal.
They should not file.
Yes, yes, they have filed.
To save time, to save
Yes,
money,
to save litigation
and according
yes.
to the government,
Yes.
below 2 crores
It should not be filed.
is
Supreme Court,
just
yes,
for them,
yes,
leave it.
Yes, yes.
But then how can it confer benefit on a third person?
Then it is the direction for all types of appeal, whatever litigation they will file, that will be binding. CBC instructions. And lot of judgments are there, my lord.
They are there, but then this is the question which occurs to me.
This also will taking on record submission of the revenue that monetary limit for filing appeals to the Supreme Court by revenue in indirect tax matter has since been increased 2 crores as per CBSE order 2/11/23. Appeal was to be dismissed in present matter on account of law tax effect. And on that ground it was dismissed. Then Calcutta High Court also at page 293. Casta appeal number 12 of 22. Commissioner of Customs Preventive Kolkata versus Gulshan Ahmed Barbuya. This is also betel nuts case, Caesar case. This they have dismissed this appeal on the ground of.
My lord, what I would submit, my lord, The circular my friend is referring to is issued under section 131AB of the Customs Act, my lord. Your lordship kindly sees, my lord. Page 290.
219.
290 of the paper book, my lord. 290. Well, the circular itself says, my lord, in exercise of the powers conferred by section 131, capital B, capital A, my lord.
Yes.
Now, if we come to Customs Act, my lord, if I may just refer to the Customs Act, my lord, 131 AB, BA, my lord.
Appeal not to be filed in certain cases.
I'll just read. 131 BA may says, the board may from time to time issue orders or instructions or directions fixing such monetary limits as it may deem fit for the purpose of regulating the filing of appeal, application, revision or reference by the Principal Commissioner of Customs or so and so under the provisions of this chapter, my lord. Now this chapter starts, my lord, from section 128, my lord.
Section starts from?
The chapter 15, my lord, consists of sections 128 till 131.
Yes.
Remember, this chapter deals with departmental statutory appeals, my lord. 128 appeals to Commissioner, 130 is appeal to High Court. Now here, my lord, in this case, they invoked 226 of this Honorable Court, my lord. They came by way of writ petition, my lord. So in my humble submission, my lord, the 131 BA bar will otherwise also not come into picture, my lord. Apart from what has fallen from your lordship, that this does not inure any benefit to them. This is for our internal matter, my lord. If any officer transgresses that limit, he'll face the consequence for that, my lord. And even this bar is not an absolute bar, my lord.
Yes.
What 131 BA says, my lord, in subsection 2 itself, my lord. Sorry, my lord. My lord, at page 290, my lord, paragraph 2. This bar is otherwise also not absolute bar, my lord. It says adverse judgment relating to the following should be contested irrespective of the amount involved. Where the constitutional validity of the provision of an act is under challenge, where notification, instruction, order or circular has been held illegal or otherwise, classification and refund issues which are of legal and or recurring nature.
Yes.
So, my lord, my twofold submission before lordship, my lord. In fact, threefold, my lord. That these are writ proceedings, my lord. So this circular is not applicable. First, my lord. Second is that the bar under the 131 BA is not an absolute bar, my lord. The circular itself provides that when involves question of law, refund issues which are of legal and or recurring nature. So this is not an absolute bar, my lord. And my
In that page 290,
my lord,
how do you get that?
at para 2, my lord. Para 2 says, my lord, adverse judgment relating to the following should be contested irrespective of the amount involved. Now, sub para C, my lord, classification and refund issues. But this is a refund issue, my lord, which are of legal and or recurring nature.
Where is that notification?
It pays 290.
And where do I get that your
The exceptions, my lord, that is it, para 2 of the notification, my lord.
yes?
So, my lord, the main contention would be, my lord, that the 131BA notification will not cover writ petitions, my lord, or writ appeals, my lord. Otherwise also, my lord. The impugned order is at 255, my lord.
Sorry?
Impugned order passed by the learned single judge is at page 255, my lord.
You have seized anything? Oh, it's sold, seized and sold.
Seized and destroyed, my lord. Because the betel nut was unfit for human consumption, my lord, as per the food laboratory. So we could not have released that in market or given back to them, my lord.
So you got nothing out of it.
We got nothing out of it, my lord. And there's another aspect, my lord. What happened after seizure? They came and filed an application before us, my lord, saying that for provisional release at the valuation, very less valuation, my lord. Because when it came to for them to submit a bond, my lord, then they are valuing it at lower value. Because they know that the betel nut is very inferior, of very inferior quality, my lord. Because what happens, my lord, these betel nut come through smuggling from Myanmar, my lord, and they all go to UP for making a pan masala and other things, my lord. And there's a common route for this, my lord.
So when it was released by the tribunal released it.
The tribunal did not say anything, my lord. Tribunal only said that reverse the order of the commissioner, my lord.
Which was upheld by the High Court and Supreme Court.
It was upheld by the High Court and Supreme
But
Court.
all these three courts, while affirming the order,
No,
did not say anything about the.
There was no consequential order to that effect, my lord.
And the court, while dealing with the matter, did not remark anything that you, since you have destroyed it, you pay them.
My lord, learned single judge held that it is not our lookout whether it is fit for human consumption or not. Since you lost in the departmental litigation, my lord.
No, did they make the prayer for some compensation there?
My lord, their prayer in the writ petition, I'll just take your lordship, my lord. They asked for a refund of the valuation of goods along with interest, my lord. The prayer is at page 20 of the paper book, my lord. Why the relief to the petitioner by way of refund of the seizure value of the seized goods with interest, in absence of goods as may be decided by this honourable court, shall not be ordered for unlawful destruction of bona fide trade goods without knowledge of the petitioner. But otherwise also, the adjudication happened under the Customs Act, my lord. Such relief they should have sought before the tribunal, my lord, rather than coming under 226 of this honourable court, my lord. And then they could have raised this point of limitation, my lord, the 1 crore exceeded or not exceeded. Well, filing 226 for execution, as if it is an executing court for such state, my lord. That in my humble submission is, the writ petition was not maintainable, my lord.
Then what to do? The goods are gone, what is there? But when it's single judges ordered 70 lakhs compensation. Customs, they evaluate under the customs act. Yes, what do you say?
Yes, regarding this monetary limit, my lord, this according in my humble submission, it is applicable to this case. It applies to all types of litigation filed by the customs in the Supreme Court, High Courts, and Sestat. This is binding. And secondly, this he has wrongly interpreted this clause C, classification and refund issues which are of legal and or recurring nature. It is not a legal, not recurring nature. It is a compensation in lieu of unlawful disposal of the petitioner's good, without notice to the petitioners and without permission from the appellate court where the matter was sub judice. Illegal distractions. Tribunal has held illegal distractions. They have got no power. High Court has affirmed it. Supreme Court has affirmed it. Everything has been affirmed. Everywhere they have lost the cases. And now I have filed the compensation for return of my goods. Let them return the goods. We don't want compensation. Or they may give this compensation as awarded by the largest single judge. Seizure value was 88 lakhs in 2007. This seizure value was fixed. Then this honorable single judge has awarded 60 lakh not to for non-filing any suit further. Even then, they are the compulsive litigant, my lord. They are always there. They are trying for the last 10 years. And they have lost. They have lost everywhere. Illegal confiscation that was set aside by the tribunal. High Court and Supreme Court has affirmed it. Illegal. Then illegal, unconstitutional destruction of goods. As per the manual, they have to intimate the owner. They have not intimated nothing. Regarding the time of the disposal. And there, this destruction was illegal, unconstitutional, and we want to refund back the goods. Refund our goods. As per Supreme Court judgment, I can rely.
Where is the sale notice?
No sale notice. There is their destruction. It is.
How can they destroy? Only when was it sold?
Not sold. They have destructed it. They say. Yes. They have given us information that it was sold. It was destructed.
It was destroyed in the month of March 2019, my lord.
The department cannot evade or dilute its obligation under any pretext, my lord. And all question of facts settled by the Supreme Court. When the matter was pending in Calcutta, sister, they have destroyed it. Without a notice to the tribunal.
Where is the notice?
Page 141, my lord. They have destroyed. Not only my goods, other goods also destroyed. There is about few crores of rupees, and I believe it was sold to the market in the name of destruction, all these things. Two crores 90 lakh 66,000 total value, this destruction value of 3 cases at page 141.
What are these cases?
These are other persons, other betel seizure cases. My case is at serial number 1. They have given a certificate for destruction.
My lord, may I point out the orders passed by commissioners, estate?
Yes, where is the
Well,
disposal order? Terms and conditions of disposal.
my lord, disposal order is not annexed, my lord, only the certificate of disposal was annexed, my lord. Is at page 141, lords, you've seen that.
No, where are the bidding documents or it was not sold?
It was not sold, right? It was destroyed, my lord, because it was unfit for human consumption, my lord.
Is there any provision in the Customs Act permitting destruction?
My lord,
Only if the goods are not collected from the warehouse, they have that power of throwing it into the sea.
my lord, page 137, lords, you kindly see, this is the result of food analysis, my lord.
Page
137, my lord, of the paper book. The quantities below, my lord, opinion, the samples are damaged, having fungal infestation, and hence are not suitable for use for human consumption. Yes, yes, numbers are different. And my lord, at page 145, the customs manual, my lord.
No, where is the report that it is unfit for human consumption?
But I pointed out, my lord, that is at page 137, my lord. 137. It's a Government of Assam, Office of the State Public Health Laboratory, my lord. And below opinion, my lord, the samples are damaged, having fungal infestation, and hence are not suitable for use for human consumption.
Yes, would you like to add anything?
Yes. My lord, at page 98, food test was declared as only unauthorized by the tribunal, and High Court has upheld it, Supreme Court has upheld it. Page 98, para 12. In view of above, page 98, tribunal order. Page 98, my lord.
Yes.
Para 12. In view of above, we find the betel not being non-notified goods, barring to prove the fact of smuggling lies on the department, and the same has not been discharged. Department has not discharged. The report of the RDF, Mangalore, cannot be relied upon. On the issue of goods being held to be unfit for human consumption, we hold that the said goods are neither imported nor proved to be smuggled. No action by the custom is warranted. In view of above, discussion seizure of improved betel nuts is not justified and needs to be set aside. Therefore, nothing survives in this case. An appeal is liable to be allowed. We allow the same with consequential relief as per law. So this was upheld by the Honorable High Court at page
100. 100.
100, my lord.
100.
Yes.
100. Customers filed this appeal against the order of the tribunal before this honorable court. Are 100, my lord, page.
He was writing anything in the pad. He was writing anything in the pad. Both. Back to that. Yes.
Dr. M. Mojika Lamek, Senior Counsel, yes. And
Page 100, my lord. The appellate order passed by this honorable court, my lord.
Yes.
yes. On 29/10/17, two trucks bearing registration number such and such, each transporting a consignment of betel nut, were intercepted by the appellants while they were on way to Guwahati. The appellant suspected that betel nuts loaded in truck was of foreign origin and therefore seized the said bags of betel nut under section 110 of the Customs of 1962 on the ground that said betel nuts was brought to India through an unauthorized route of the Customs Act and are liable to confiscation under section 111B and D of the said Act. The trucks were also seized under section 150 of the Customs Act. The appellant therefore gives show cause notice to the respondent for the purpose of proceeding under the Customs Act. The Commissioner of Customs Preventive, after hearing the parties by his order dated 6/6/2019, confiscated the betel nuts and the said bags of betel nuts under section 111B and D of the Customs Act and also imposed penalty of 10 lakh on the respondent. The respondent being aggrieved preferred a custom appeal before the Custom Excise Appellate Tribunal, Kolkata. After hearing the parties, this appeal was allowed by the tribunal by the order dated 9/12/2020, and this order is impugned in the present appeal. The divisional bench of the tribunal recorded the findings that the confiscated betel nuts is non-notified goods, and therefore burden to prove the fact of smuggling lies with the department, and the same has not been discharged. In this regard, the department relied upon the certificate issued by the Erica Nuts Research Development Foundation, Mangalore, ARDF, to show that the confiscated goods, betel nuts, were of foreign origin. However, the tribunal refused to consider this certificate on the ground that the said institution is not accredited and hence the report was not relied on. The tribunal in this regard relied on the decision of the Patna High Court reported in 2020 371 ELT 353 Patna. After hearing the learned counsel appearing for the respective parties and after going through the impugned judgment and order, we find no error in the findings given by the tribunal. The said findings, in our opinion, are supported by reason, and therefore we are not inclined to interfere with this appeal. Appeal has no merit and is accordingly dismissed. Against this order of the High Court, my lord, next page, they went to Supreme Court. Supreme Court, next page, 102. SAP was filed by the Customs against the order of the High Court. Dated 20/10/21. Now, Supreme Court order at 31/10/2022, page 102.
Yes.
102. We do not find any ground and reason to interfere with the impugned judgment and order of the High Court, and hence the special leave petition is dismissed. Pending application in petition shall stand disposed of. Now I file this writ petition for return of the goods. Now, Honorable Single Bench has awarded compensation of 60 lakh, which is far less than the seizure value of 80 lakh, just to end the litigation.
Where is the seizure value?
Seizure value is at page adjudication order.
Where is the seizure value?
Yes, my lord. Seizure value is at page. Order originally page. At 88, my lord. 88.
Yes.
Order. I order absolute confiscation of 400 bags containing 32,000 kg of betel nuts, valued at rupees 88 lakhs.
Page?
Page 88.
No, this is the adjudication. Where is the seizure?
Seizure, it is
Mentioned in the adjudication. Where do we get the official value?
official bill. This is the 150 also, my lord.
Page 25, my lord.
119, as my brother points out.
It's available page 25 also, my lord, and
Page 25, my lord. Official value. Page 25, Annexure 1. Seizure inventory.
You wish to say anything else?
This much, my lord.
So was there any basis on which the learned judge computed 60 lakhs? Or
no, absolutely no basis, my lord.
here at page 25 it is 88 lakhs.
It was seizure value 88 lakh, but he has reduced to 60 lakh just to end the litigation. Because they are continuing, he wants to end the litigation, so on which I had agreed. But even then they are again filing.
Where do you get 88 lakhs?
This is at page 25, my lord. Page 25 of the paper book.
Remark, 275 per kg would be 20 less.
This is the 44 lakhs estimated value. One truck 44 lakhs, another truck 44 lakhs. Estimated value in the seizure memo.
So, my lord, the seizure value was 275 rupees per kg, my lord. Now, what happened, my lord? If I may just point out one aspect, my lord, at page 264, my lord, kindly turns, my lord. Page 264, last paragraph, just point out, my lord, para 1.4. That on 24/9/2018, a written submission was received from the respondent requesting for provisional release of the seized 32,000 kg betel nut for non-consumption use, that is sale to plywood factories, at a reduced value of rupees 96 per kg. However, as the seized betel nut was unfit for human consumption, the same was not released on provisional basis, and the same was informed to the respondent's counsel by later dated 26/11/2018. So they themselves agreed that the valuation should be 96 rupees at one point of time.
Do you know any rules by which the owner of the goods has to be noticed before sale?
Yes, no notice was given, my lord.
Where, under which rule you are supposed to get notice?
Yes, that is I am showing. 283. My lord. Custom Disposal Manual 2019, that apart from the illegal food test without knowledge of the respondent and in gross abuse of Section 144 of the Customs of 1962, Appellant Authority has also vitiated the provision of Disposal Manual 2019 issued by the CBIC, wherein no intimation of pre-trial disposal of the goods was given to the respondent. Relevant portion of the Custom Manual is reproduced below. Apart 2.3.3, apart from the goods which are likely to be deteriorated or perish, the seized goods for which the recurring cost of upkeep or cost likely to be incurred on the special arrangement required for storage is disproportionately high, may be disposed of after observing prescribed formalities and after due intimation to the owner or claimant about the date, time and manner of such disposal. Nothing was given, no notice was given. It is a violation of Custom Manual 2019. No intimation was given regarding the date, time and manner of disposal. This is distraction. And this was done when the matter was sub judice before the appellate court in tribunal, without permission from the court, without permission from the appellate court, disposal was made illegally, and without a notice indicating date, time, and destruction of
Where is
the
your valuation saying it is zero value?
88 lakhs, my lord, as per 25, page 25. At that time, my lord, now much more than that. Seizure value 88 lakhs at page 25.
So we are concluding the hearing?
Well,
Hearing concluded, CB.
now, just to summarize, my lord, my submission is that 226 cannot be invoked for execution of an order passed by state, my lord. That is our primary plea, my lord, apart from others.
It's all confusing, my lord. I can file for return of my goods. It was seized.
It is not an appeal. Appeal was carried to the High Court and then to the Supreme Court.
My lord.
Yes, ma'am.
This is an issue, ancillary issue coming out of the appeal.
My lord, primarily he wants execution of sestate's order, my lord. Sestate is an order where he succeeded, my lord, and subsequently appealed to High Court and SLP dismissed, my lord. So primarily he has to go and file execution before the sestate, my lord. Instead of doing that, he comes and files a writ petition before
You
the
see, we are not taking this point in a writ,
my lord.
but in a suit, this technical point is taken. And I don't know why Supreme Court or the High Court DB did not go into it. You see, your entire claim has to be included in the plaint.
My lord.
If it is not included, you cannot file a second suit.
My lord.
So this is part of the claim that goods destroyed. My claim for damages is 88 lakhs. This is a kind of a separate proceeding you are taking out, which is barred under Order 2, Rule 2. But we are not taking that rigidly in a writ. The Supreme Court has not gone into it.
Yes.
And this is not a section 100 and something appeal under the Customs Act, 129.
It is not.
It is.
Writ appeal, my
Let us see what can be done. Huh?
lord. My lord.
Hearing concluded, say, would you like to file notes?
I can give in writing also, my lord. What should permit me?
Same, either party, like in the other matters.
Yes.
With this,
I'll file the written.
with the court master attached to this court.
My lord, kindly grant 3 days time, my lord.
No, you will get more time, 1 week's time, up to.
My lord.
Up to. Today is 24th, up to 3rd March.
Much obliged. Much obliged.
What's the remaining matter in the list?
Item number 6.
May I please, Your Lordship?
The 2 page, another one. Yes?
Lordship, in this matter, I'm praying for time, Lordship. The senior counsel in this matter, Lordship, he got leg fracture, so it will take time for him to recover. 2 weeks time may be granted, Lordship.
What do you say?
He is
What do
having
you
some
say?
personal difficulty, my lord.
All right. Then for the appellant,
Lordship.
is considering the personal difficulty of learned counsel for the appellant, as pointed out by his junior, to be adjourned to this appeal till 10th March.
Obliged, Lordship.
Item number 7.
This is the matter regarding reimbursement of medical allowance, my lord.
Tomorrow we will take it up.
My lord.
We will take it up tomorrow.
Much obliged. Much obliged.
All right.
Tomorrow.
Okay.
List this appeal, this writ on 25th for further hearing.
Much obliged.